5 prisoners standing trial in Johannesburg have instituted legal action to secure compensation of 10 million rands after what they claim are damages for pain suffered and emotional trauma. They say this was caused by the assault, torture and loss of amenities at the Leeuwkop Maximum Correctional Center in Gauteng. This was in 2014. The inmates say they were beaten with batons, punched, slapped and electrocuted during the incident. Joining us now to discuss their case is one of their legal representatives, Nabeelah Mia, an attorney of law for Lawyers for Human Rights. Nabeelah, good evening, and thank you very much for your time. According to court papers that we are reading here, the department is admitting that the prison officials used some force, but they are denying that the use of force was excessive in the manner that the inmates are alleging. What is your understanding then from what is being related by your clients on how this matter happened?
Thanks so much for having me this evening, Tabo. Well, in terms of what prompted this case, if we go back to the day of the 10th of August 2014 and 3 days before that, at Leeuwkop Correctional Center, where our 5 clients were inmates at the time, 2 of them have subsequently been released on parole. But at the time, on the 7th of August, our clients were in a cell that was subjected to a routine search for cell phones and other contraband at the time. The search ensued on the 7th of August, 2014. Our clients who were in the cell of a number of inmates said that they were told that there was certain contraband that was found, including cell phones, but they were never shown that contraband that was found in their cells. Subsequently, the entire cell was demoted and privileges were taken away from the inmates, and those privileges included visits from their family and certain privileges that you are able to access if you accumulate certain points as inmates. And so in sort of protest of this, one of our clients wrote to the head of center to petition against this demotion and loss of privileges, and he received no recourse. In fact, according to reports to him, his letters were torn up by the prison officials. So on the 10th of August, when the cell was opened, our client admitted to blocking the door so that to get the attention of the prison authorities. And he demanded to speak to the head of center. What happened then was that the prison officials then gained access to the cell after it was blocked by our clients, and they subsequently assaulted and tortured the members of that cell.
Yeah.
As a form of retaliation, one would say, for their actions.
Yeah. So this was a form of retaliation for them having blocked the door in Claim B. Talk to me then about the injuries that they sustained. I mean, this is also in dispute. To what extent were your clients injured?
Our clients were quite significantly injured. Just to run through the injuries, that some of which you mentioned, they were slapped, punched and kicked repeatedly. They were beaten with batons. They were set upon by dogs. They were shocked with electric shields. They were forced to do handstands for a prolonged period of times. They were subjected to searches of their body persons beyond what is allowed and prescribed. And then 4 of our clients were subsequently detained in single cells conditions akin to solitary confinements for about 15 days after that. And during that time that they were segregated, they were shackled for 23 hours a day. They were denied access to medical care and denied adequate and sufficient bedding. And the injuries that our clients suffered, and these were verified by by medical officials continue to this day. Our clients continue to experience injuries to their spinal cords, ongoing pain in their limbs, degeneration in their spines, ongoing urinary dysfunction, neurological dysfunctions, impairment in their limbs, restricted movement in their limbs. And beyond those physical injuries, our clients are currently still experiencing psychiatric injuries, including post-traumatic stress disorder.
So you are categorically opposed to the view that the use of force was justified and was a precautionary measure taken in self-defense?
Yes.
And what are you asking the courts to do?
Well, we are asking the courts to find that the assault that our clients experienced constitutes torture for purposes of the Torture Act in South Africa. This is the first time that we are asking the courts to do such a thing, to find that it goes beyond assault. It actually constitutes torture as it's defined in the Torture Act.
None of the inmates, this is what the department is saying, were actually kept in segregation, but they were only separated. What's the difference?
I'm still struggling with this one, but because the Correctional Services Act itself only provides really for segregation in terms of Section 30 of the Correctional Services Act, or accommodation really. And accommodation is when inmates need to be in single cells, because in some instances they're furthering their studies, so they are accommodated in a single cell. And what the department is arguing is what occurred was separation. But there's no provision in the Correctional Services Act or any form of law that provides for separation, which is what the department is arguing. So what we are arguing is that our clients were actually segregated, and the provisions that the department officials were to comply with as they relate to segregation, the department did not comply with those provisions.
Yeah. Why are your clients specifically bringing particularly two claims against the minister? On what basis are you doing this?
Well, the first claim relates to the physical injuries and the psychiatric injuries that our clients have suffered, all 5 of them. And then the second claim relates to the torture of segregation or solitary confinement that 4 of our 5 clients were subjected to.
Yeah, and why not take that to the department itself, but why are you taking it directly to the minister?
Because the minister, in his capacity as the Minister of Justice and Correctional Services, is vicariously liable for the actions of the officials. So in the same way you would have the employer-employee relationship, where an employee that commits certain acts during the course of their employment, the employer is liable. This is the same way we are holding the minister to account.
All right, appreciate your time. Thanks very much for coming on. Nabeelah Mia, an attorney for lawyers for human rights, representing the 5 who are claiming damages, inmates there, from the Minister of Justice and Correctional Services. Let's remind